In the ongoing saga of the lawsuits against Suno and Udio, this includes not just the lawsuits that my law office filed, but also the ones by the major record labels. And the update, this actually comes from Music Business Worldwide, is that Suno and Udio seem to have joined forces, facing stream ripping allegations from the labels. Suno Udio weigh in on separate case to challenge ruling that makes YouTube downloading illegal. All right, so context, right? So the basis of these lawsuits against Suno and Udio is not that we are anti-Suno or Udio, is specifically that these companies have each admitted that in the training of their AI, they went to publicly accessible platforms. They didn't say what that meant and grabbed a bunch of songs. And we go, what does that mean? So as this has been an ongoing journey to discover this information, there have been a few different sources that have come out in recent months and said, we think or we know that these companies came to our platform. And one of the reports was published in Billboard. Some information was provided saying that, in fact, one of those platforms was YouTube. So the AI music making platform, Suno Udio, recently added allegations, and this was across the board in all the lawsuits, that Suno and Udio stream ripped copyrighted music to train their AI models, and that they stream ripped it specifically from YouTube. As this claim works through the courts, Suno and Udio have filed an amicus brief. Pause 2 seconds. An amicus brief is like a secret report that you're going to file into a case and you're like, hey, I'm not part of this case. I'm not a plaintiff. I'm not a defendant. I'm going to put together this little report that I'm going to give to the court because I think that they need to know something really important. And there's a bunch of reasons why you would do this. Now, notably, I talked about this amicus brief thing as part of the Drake lawsuit. If you guys remember, we just reported that Drake's entire lawsuit got dismissed. And we went through and we go, in our analysis, we wonder, was it because of this amicus brief that was filed by this group of experts from the University of California? They're like, we know all about rap lyrics. This whole thing is about a beef and they're going back and forth court. You got to just kick out this whole complaint. So we go, wonder if this amicus brief was the thing that swayed the court in the Drake lawsuit. So here we go, looks like Suno and Udio have filed this amicus brief in this other case that doesn't have to do with their lawsuits, but it directly impacts what's going on in these lawsuits. So they filed this thing in a separate case, and they're arguing that a 2022 federal ruling wrongly declared stream ripping illegal under the DMCA. What's the DMCA, you ask? So it's under the Copyright Act. It's the Digital Millennium Copyright Act. And so this little section in the Copyright Act that was made to protect against online stuff. Don't know if you know this, but back in the day, there was no internet. And so the Copyright Act didn't have stuff in place to deal with internet wrongdoing and piracy and whatever. So the DMCA was put into place. And so as part of this case, what they're saying is that stream ripping, which is what we're going to talk about here as it relates to YouTube, was determined to be illegal. And if it's illegal, that's not good for these companies if the allegations against these companies is you went and stream ripped off of YouTube. All right, so the AI companies warn that the ruling threatens fair use by misinterpreting the law's distinction between copy controls and access controls. Stream ripping is a type of online service that users can enter the URL of media on YouTube or another streaming service and that have content download to their device. The issue has become relevant now in the Suno and Udio cases right now that all of our lawsuits are essentially claiming that they committed this really important violation. Okay, so in other words, we're like under the DMCA, it says that if you go and you access something and you had to break through technology in order to access the copyrighted content, it's a different violation. This isn't like just you stole the thing, you downloaded the music, you trained your AI, because everyone's on the same page with that, with all these lawsuits. And they're admitting it. They just say, yeah, we did it, but we think fair use applies, and fair use is the wipe the slate clean defense. And so if they're successful in claiming that they had a transformative use and fair use applies, they survive. And they don't have to pay anything. They're good. The reason why this matters is that with the DMCA, it's a different claim. And so if they lose on the DMCA, then they could be found liable for a different claim altogether, different damages. So it's a big deal. So what they're trying to do is that they've put together this little brief and they have filed it into this other case right now that's ongoing. It's on appeal. And they're trying to inform the court, to sway the court to be like, we think the lower court got it wrong. The lower court said DMCA violation, it's illegal and all this stuff. We don't agree. So we're going to try to get to the bottom of this. What are they saying? They have petitioned the court to add allegations. So this is in our lawsuits. So adding the stream ripping, this is new, right? Add into all the lawsuits. But the question of whether stream ripping is illegal is currently before the courts in a long-running case that has pitted a stream ripping company, Yout, hopefully I said that right, against the Recording Industry Association of America, right? So the RIAA. Notably, the record labels suing Suno and Udio, owned by Sony, Universal, Warner, they're all members of the RIAA. So they're just kind of like, this is somewhat closely related. So in this brief that was filed into this Yout appeal, the two companies urged the appellate court to overturn the 2022 verdict, which declared that stream ripping is illegal, right? It's a big no-no. So saying that ruling, quote, jeopardizes the fair use doctrine by misconstruing the DMCA. And it suggests that anyone who downloads a YouTube video, including not only AI startups, but also documentary filmmakers, teachers, and the like, is liable for statutory penalties under the DMCA, even if that person's activities fall squarely within the contours of fair use, says Suno and Udio. Okay, really just pulling on the heartstrings there, aren't they? Here's what it says. It goes, the DMCA, it's broken into two pieces, and they're like, for one of them, if you access, you break through technology, which is what the claim is here in all of our lawsuits. We go, if you break through technology, it's a violation of DMCA because you don't get to go in and get the song. You're saying you did it. You don't get to go to the video, scrape the song out of it, scrape the video out of it to then train your AI. So we're saying you access, you did the bad thing. What they're trying to argue is they go, no, we didn't access it. That would be a violation, but we didn't do that. We just copied. Now, at the end of the day, what they're trying to do is just kind of hide behind this. You're like, well, if you're just like a little YouTuber and you're doing, a reaction video, you have to download the video, right? And I think that's a pretty, we can nod our heads along with that. Like, that makes sense. But obviously, the argument is twofold. One, if you're a YouTuber and you're doing a reaction video, you can have the video on YouTube playing and you use your OBS and you stream it and you react to it. You don't actually have to download it. So that argument fails. But the second really important piece here is when courts have looked at this issue, they go, ultimately, what were you doing so that you downloaded the video and then what? Did you download the video so you could do a fair use reaction video analysis? Or did you download the video so you could pirate the song to train your AI without authorization? In my opinion, it's going to matter it's going to matter a lot between those two things. So anyway, what they've done is that they have filed this amicus brief into that court because that court is now looking at that issue. And obviously, if they're able to get that court to overturn the prior ruling, well, that could be really good for their defenses and their cases against our lawsuits. The legal battle between RIAA and Yout began in 2019 when the RIAA sent a notice to Google asking the search engine to delist, so this must have been the website, YouTube-DL. The stream ripping service operated by Yout LLC, the stream ripper, responded by suing RIAA. So they didn't like the fact that the RIAA had sent a notice to Google, and I guess obviously it was effective. So they sue, arguing that its stream ripping activities don't violate the DMCA. But the judge in that case ruled in the RIAA's favor, effectively declaring that the DMCA prohibits stream ripping. Yout appealed that ruling, and a number of digital rights advocates, such as Electronic Frontier Foundation, have also objected to it, arguing that the judge's broad interpretation of the DMCA threatens to upend the fair use of copyrighted materials by giving rights holders the ability to stop fair use of their content. So again, the argument that they're trying to make here is they're like, you poor little YouTuber, in order for you to do the reaction video, you have to go download the video. So they're like, in downloading it, if you just download it and it's this whole violation of DMCA, that's not good because you kind of have to. So again, that's the piece where we're kind of nodding on for a second. But again, it just fails because really, what's the effect of this? Truly, think about it. If ultimately The court comes and everyone's just on board. They're like, you know what? We agree. Anyone should be able to go to YouTube, download any video, even though you can't do that on YouTube. That is against YouTube's policy. It specifically says in its terms of service, you can't do that. And it has this thing called a rolling cipher. So it changes the address. And that's why you have to go to one of these stream ripping services to download the video. So if you go through all this, backflipping or whatever, to get the thing, and ultimately everyone's like, that's cool, you can do that, then that ultimately would be free reign for AI companies. That's the impact that this would have. So said another way, if ultimately it's okie dokie to go onto YouTube, to go and scrape any videos, any music, to then train your AI, every AI company is gonna go and do this. So obviously this is a very big deal. It would be great for Suno and Udio to have this kind of ruling. It would be pretty, I would say, devastating in impact on the protection of creative stuff. Because let me put it, another way. Like, do you put your music onto YouTube with the expectation that anybody can come and just download your stuff, resell it, license it, train AI on it, do whatever? No, of course not. Copyright owners release their stuff with the expectation that if you put it on a streaming platform like Spotify, it's just going to get streamed. They don't get to do extra stuff with it without your permission. You have an expectation you're putting on YouTube. They get to watch your video. They get to listen to your song. They don't get to download it. So that's why, again, this is important. All right, groups representing rights holders, such as the Copyright Alliance, have also stood behind the RIAA. Quote, Yout's illegal stream ripping software is a significant threat to copyright holders and ultimately the public. If this court adopts the arguments of Yout and its amici, protection of the numerous business models will be devastated, resulting in less, not more, public access to copyrighted works. So I'm curious, what do you guys think? It's an interesting argument, but at the end of the day, I'm curious what you think. So drop a comment down below. I'm top music attorney, Miss KRYSTLE.